Alex here with part 165 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my ex's attorney's reply to opposition to our motion to strike. I think I mentioned in the last, or not the last video, but the video before last, that this is just one of the 6 documents in a brief over 2 issues. And this is just one of those briefs that's arguing that everything I'm doing is mean and it's not fair and it's harassing her. And for the most part, I think this particular document is going to contain even more copy pasting than any of the others we've gone over, because I kind of think we've thoroughly covered all of the issues from both different angles at this point in time. So as with the previous documents, if I see a section of this particular lawyer's reply that is just copy paste, I'm going to just go ahead and scroll through it. Remember, when it comes to the documents in the My Docket series, you can always go down into the description below, click on the link, download the document for yourself and take a look, just in case you think there's something that I overlooked or something that I should discuss, and you can always mention that down in the comments below. All of this being said, I think we should really just go straight into what my ex's attorney has filed. Here we have the reply to opposition to motion to strike. And this is standard introductory paragraph indicating that my ex is appearing by and through her attorney, and that he is going to reply to our opposition to motion to strike. By the way, guys, I mentioned 6 documents in the brief, and this is document number 6. So after this, we're done with this particular debate. Let's go into points and authorities discussion. Let's see here. Monica mailed the motion to strike where she believed counsel's Caffaratti off. Okay, so this attorney, why is he saying what? This is odd. Well, he probably, okay, so he's saying my ex mailed it, but he's probably just saying that in the sense that he mailed it for her. So what's going on is this attorney is saying that he mailed everything to this address, 50 West Liberty Street. Okay. Unfortunately, she does not accept electronic service, etc. Okay, so he's saying that she was served. This issue doesn't get discussed at a hearing, nor does it get discussed at any point in time by any, by the judge. So I'm going to just skip through this, guys. I'm assuming that the lawyer probably did serve her at this other address, and that she probably, for whatever reason, wasn't there or didn't get that mail. To me, this is really a non-issue. I don't really want to talk about it because, I didn't even really think to raise this argument. As soon as I found out the documents were filed in the system, I just pulled them, and we worked on our opposition and such. So, oh, wait a minute. Why is he saying this? The execution was filed by me rather than the attorney. No address was listed on the execution. Guys, executions are issued by the clerk. He keeps saying this. Maybe he doesn't know this, but I think he probably does, and he's just trying to make us look bad. Okay, so again, guys, even if the attorney did the writ of execution, it would still be issued and filed by the clerk. There is no spot on there for a signature from an attorney. There's a spot on there for a signature from the clerk only. It's a writ of execution. It's not a motion. It's not a reply. It's not an opposition. It's not a pleading. It's nothing. It's just a clerk's document. Anyway, let's continue on. The writ of execution is a fugitive document. Okay, so he's regurgitating the same arguments we already went over. Wait, maybe he has a different point here. Hold on. Okay, so for sure, NRCP 11, he's just copy pasting. This is the same exact thing that he put in his motion. WDCR 23, same exact thing. So he's regurgitating his arguments for sure. I'm arguing that because NRCP 11 is typically used to sanction parties and their attorneys, it does not apply to this manner. That's not really what I'm arguing. That's not what I'm arguing. One of the requirements of NRCP 11 is that the attorney of record must execute documents filed in Nevada courts. The reasoning behind this is to ensure the document has been reviewed by the attorney. So again, he's using this word, must execute documents, but where did he get this from? Where did he pull that from? It's like he's just trying to trick the judge. And it works. So, I mean, can we really blame this guy for what he's doing? It's frustrating because it's wrong, but why does it matter if it's wrong, if it works? If the judge is entering orders in error, but the orders are actually being entered and they are actually enforceable, to him, why should it matter that what he's doing is wrong and nonsensical? I mean, the guy's doing what works. Whether or not it's correct does not concern him. My ex does not pay him to apply the law correctly. My ex pays him to win. I talk about this in the video, Win at All Costs. It's a great video for people trying to understand the rationale behind why attorneys work this way. The writ of execution is contrary to the court's order. Okay, so this is the same arguments that he was using on the debtor's exam, so I'm going to skip through this. And then the request for attorney fees. Most likely this is... Okay, yeah, this is, again, regurgitated arguments. He's just copy-pasting the same stuff that he put in the motion. So my ex mailed her motion to strike to what she believed. Okay, so again, this is discussing just the service stuff. The affirmation. It looks like we're almost done with this document. A certificate of service indicating this document was mailed to my attorney. Request for submission. Okay, so this is, again, we've gone over these quite a few times, guys. If you want to learn more about the request for submission, take a look at the video on the topic. He is just submitting to the court the particular issue on the writ of execution. Certificate of Rule 5 service. Yes, this is indicating that this document was mailed. Wait, I'm confused here. This is our request for submission? Oh, okay. So it looks like this lawyer forgot to submit his own. Okay. He didn't even submit his own documents to the court. Okay, for whatever reason, this lawyer did not submit his own documents to the court for consideration. So we went ahead and submitted it for him. Rule 5 certificate of service indicating to this lawyer that we went ahead and submitted his documents for him because he forgot to do it. That's weird. Really weird. Anyway, notice of entry of order. This is indicating who's entering this. Okay, so this is the lawyer actually entering the notice of entry of order on that previous order that was entered by the judge. If you want to learn more about the notice of entry of order, guys, take a look at my video on the topic. And the certificate of service here is... Right, okay, so it's indicating that this document was mailed to my attorney. Index of exhibits. This is just going to be the order denying motion for blah, blah, blah that we just went over in the last video, guys. I'm not going to go over it because it's a duplicate document. It's the exact same order. There's nothing new about it. Okay, amended certificate of service. This, why is he entering this? He must have sent it to the wrong address. Okay, so this is just the attorney correcting his previous certificate of service. Apparently he sent it to the wrong address, and here he is sending it to the correct address. And that's... should be it. Okay, he also adds a certificate of service to his certificate of service, which is weird. I've never seen that done before. That's definitely not supposed to happen. You don't serve certificates of service. That's just weird because you just don't do that. That's really weird. If you file a proof of service or a certificate of service, you're telling the court, this isn't for you. This isn't for your ex. This is for the court. You're certifying to the court that the document was served. You don't have to certify to your ex that the certified certification was served. Anyway, he probably I guess maybe this guy is really new. It's possible that he's really, really, really new. That's the only thing I can guess. Okay, I'm going to go ahead and move on. Going into the aftermath, I filed the request for submission. One document, but it was a free filing, so I incurred $0 in costs. My ex's attorney filed 3 documents. They were all free filings, so she incurred $0 in costs. I had an attorney who helped me for free, so I incurred $0 in attorney fees. My ex's attorney would have spent some time on that reply, even though it's mostly copy-paste. I don't think I would really say that it was a full hour. But if you take that document and you lump in the notice of entry of order and the amended certificate of service, then I guess that does probably round out to about an hour. So at the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As with the previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.